The issue is you exploded because she got dirt in your tool. You didn't like that. You tried to take something away from her, and she stood up to you. She took control. You did not like that. We will go on the record in the matters 23 CF 189, 24 CF 163, State of Wisconsin versus Christopher Stewart. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Stewart in person with counsel Nicholas Davis. We're set here today in this matter for two things. One is for a status conference on 24 CF 163, and the other is for a sentencing hearing in 23 CF 189. Mr. Davis, can you please give me a status on the 24 matter before we proceed?
Your Honor, it's not resolved, but may I ask you for a little more patience? I think it has the potential to resolve. I just need another opportunity to speak with District Attorney Schmidt. I'm not asking for that 90-day mumbo jumbo. If I can just have 30 days, Judge, I'd appreciate it.
All right, for that matter, all right. And we are in victims' rights compliance for that matter, yes. Okay. And are we in victims' rights compliance for the 23 case? Yes. Okay. Are we ready to proceed on the 23 matter?
Yes, Your Honor.
Okay. Well, with the 24 matter, Mr. Schmidt, Mr. Davis is asking for additional time to be able to negotiate with you to see if the matter can resolve or if we do need to set the matter for trial. I don't believe that we've had any type of speedy disposition request from either Mr. Stewart or from victims. I do know that victims would like to get the matter resolved as quickly as we can, but not, it hasn't been requested to get it done now, so to speak. So is an additional 30 days objected to?
No, and basically nobody wants to have trials where young children have to testify if they don't have to.
All right, so then that's fine with the 24 matter. So we can go ahead and get that set right now for an additional status and see where we're going to go with that. Mr. Davis, you are coming back on February 10th at 11:30. February 10th at 11:30. We can go ahead and set that at that time.
Yes, Your Honor. Thank you, Your Honor. Your Honor, and
date on that.
What?
I missed the date on that.
February 10th at 11:30.
February 10th.
Your Honor, those other two matters, you'll allow me to appear by Zoom. May I appear by Zoom for this, please?
You may.
Thank you.
Okay. Now let's proceed to 23 CF 189 for sentencing. Mr. Schmidt, you may begin.
Sure. This is kind of a hard one to do for sentencing, in part because it's a deferred judgment conviction that got revoked for commission of a new crime. The defendant has not been convicted of the new crime. He's presumed innocent of it. Normally what I would say in these cases is I usually go for a probation first when there's revocation of a DJOC, and that's because most of our revocations for DJOCs are for non-payment of fine or them not doing like the programming required on the DJOC.
The video begins with the court addressing the unresolved matter involving Christopher Stewart. The defense attorney, Nicholas Davis, requests more time to negotiate, hinting at a potential resolution. The tension in the courtroom is palpable as the judge considers the request, emphasizing the importance of resolving the matter without dragging young children into trial testimonies. The defense's plea for patience adds a layer of suspense, as the audience wonders if the case will be resolved or head to trial. The judge grants an additional 30 days, setting the next status conference for February 10th at 11:30 a.m. This decision leaves the unresolved case looming over proceedings.
Mr. Stewart's done the programming on this DJOC, so probation, do anger management, DV, that would make sense because he's already done that. I'm going to be asking for some jail time on this, and the reason why has to do with his history. If you look at CCAP, Mr. Stewart looks like he doesn't have much history. If you look at CCAP, you see a single forfeiture ticket in Grantsburg for DC. You see Minnesota, some weird misdemeanors for traffic violations regarding equipment violations, and a 2008 DUI, and that's it. When I look at it in Protect, though, I see there have been a lot of charges filed against Mr. Stewart over the year, and I wondered why none of those show up on CCAP. And the reason why is 2019, Mr. Stewart, domestic DC, did a DJOC there, completed it. That's why it's not on CCAP, got dismissed. Did a DPA on another domestic DC in 2017, completed that, got dismissed. Ordinance on a DC in 2014, another ordinance on a DC in 2014, ordinance on a domestic DC 2011. 2005, felony child abuse, DPA, completed, dismissed. So there is a trend that goes back 20 years, at least, to disorderly behavior, domestic related behavior. That's gone unabated. It also shows that when he's completed numerous DPAs and DGOCs, meaning he's done the conditions without getting in trouble on those. This would be the first one I believe he hasn't. For that reason, I think the court for this, the DGOC wound up being on the misdemeanor battery. I think the court should consider jail time between 3 and 6 months. I think 9 months would be too much because I don't know how much jail he's done in his life. It can't be a lot. I can't imagine he's done more than 10 days jail at a time. So ratcheting up to 9 months wouldn't make sense given his lack of actual criminal history. But I think because I don't see what probation would do in this case. We're supposed to first consider probation. I don't know what need they would actually address because he's fulfilled the programming requirement of the DJOC. I think that we're really about punishment and we're really about like deterring the behavior. I'm hopeful that getting jail for the first time for this sort of conduct ever might deter his behavior better, because he's been charged with it and gotten ordinance or DPAs and DJOCs constantly for this sort of behavior. Thank you.
So I guess I missed, how much did you ask for?
I asked for between 3 and 6 months jail.
3 to 6 months. All right. Mr. Davis.
Thank you very much, Your Honor. So, Your Honor, while that may be true that he have had deferred cases in the past and successfully completed them, that resulted in no conviction. And so you have to look at the convictions, not stuff that was where he did not get convictions or receive convictions, whether it be an ordinance or deferred. Now, Judge, this is a lot different from those other cases, and I'm going to be quite poignant on this. We were prepared to go to trial on this, and the issue, first of all, I'll say that this is a serious offense. I think it's a lazy argument to say it's a misdemeanor or it's a low-level felony. Let's just get that out of the way. This is a conviction. This does not bode well on his record. My client is employed full-time, and he will not get business if people start doing searches on him and seeing misdemeanor convictions. That doesn't help him. Or if he wants to switch and go to a company or a different company, this obviously isn't going to be a badge of honor. But this specific situation, so he was building a house, and he has his daughter. It's a separated family. They're divorced. So there's the child, the ex, and he, and they have shared placement time. And she comes over, and every time she's at that teenage age where she'd have chores, she wouldn't do them. She wouldn't do her homework. She wouldn't help with the chores. She wanted a new house, and he did everything to build this new house on what I call a creek, not a river, but a beautiful home that he wanted to build for he and his daughter. And they were working. And he kept telling her, will you start helping? Will you start helping clean up the lumber? And he did take a piece of lumber, Your Honor, and he did not intentionally throw it at her, but he threw it in her direction, and the board hit her. And he was a frustrated parent. He wasn't trying to hit her or smack her or take a board and hit anybody. He's like, come on, you just help, start working, start helping with the chores, help me around here. Not just don't come over and sit on your phone or your iPad or whatever it is. Now, yes, he could have tried something different, maybe grounded her or tie him out, but he threw a board. But he did not try to take that board and throw it at her and hit her with it.
The focus shifts to the sentencing hearing for case 23 CF 1189. The district attorney, Kevin Schmidt, outlines the defendant's history, revealing a pattern of domestic-related behavior that spans over 2 decades. Despite the defendant's completion of previous deferred agreements, the DA argues that jail time is necessary to deter future misconduct. He recommends 3 to 6 months of jail time, emphasizing the need for punishment over probation. The DA's argument is compelling, as he highlights the defendant's repeated charges and the lack of consequences so far. This leaves the courtroom in suspense, as the judge weighs the defendant's history against the need for justice.
In any event, he understood that that's not how to handle that situation. He entered into the deferred judgment of conviction, and he did have some requirements to do an anger management assessment and follow through, which he did do, Your Honor. And then I believe he also had another assessment with, I think, parenting and child parenting, and I believe he completed that. What's really tough right now is that he hasn't had much contact with her, and hasn't even had so much as seen her in months, didn't see her for the holidays. And now I believe she's moved from Grantsburg School, Your Honor, where she's always gone, and now she's moved to Pine City School. Her grades are abhorrent. Her grades were not doing well in Grantsburg, but I believe they're even worse now. And so I know that children, they like to make decisions. And I know that if you're under 18, you're a minor, you're a child. And it's a lot easier, Judge, I know you've seen this, to be with a parent that gives you the freedom, the video games, that can do whatever you want, and all these things. And yeah, that's nice. And sometimes the parents migrate towards that. And sometimes the parent that has homework time, we sit down for dinner together. You need to help me with some of these projects around the house, and you have chores. Yeah, that's not the fun parent. I know that. I had 2 parents like that, and there's always a chores, or there's always something. And when I'd see my friends playing or skateboarding or swimming, and I'd have to do these things, yeah, I thought I had the worst parents in the world. But looking back, I didn't. I had parents that cared enough to want to see me have some structure and succeed. What I'm getting at is he's got this criminal conviction for misdemeanor battery, and his daughter was involved in this. And again, he took a piece of lumber and he was upset with her. But I just want you to know, Judge, he did not throw that to hit her with it. He was, get going, get your butt moving here, help me out. So, Your Honor, he does work. He makes all his child support payments. He does whatever he can to support his daughter. Strike that. I don't know if there are, I'm going to strike that, the child support payments. I don't know enough
No,
about.
I know that. And I saw him say, no, he doesn't.
Well, he, and I don't know, I don't do family law anymore, and I'm certainly not representing him in this family law case. And I think there's something going right now currently with that. But so I'm not representing him on that. But I do know that when it comes to any extracurricular, or if there's clothing or whatever it needs, she's not denied any of that. And quite frankly, he's going through, I think, hell right now because he can't talk to her. I don't think the mother's allowing him to speak to her. And quite frankly, I don't think there's any order of this court that denies him that contact. I think if he is to be around her, it's got to be with someone supervised or someone 100% there with eye contact around him. I think that's my understanding with any 18-year-old or younger. But in any event, he's still being denied that access. And so I don't, again, I understand, is this a serious offense? Yes. What is the character of the defendant and his rehabilitative needs? I think his character is strong. I think he did everything he could to follow the deferred. Again, he's got another charge pending, but he does enjoy the presumption of innocence. And that case, again, is not resolved. And I don't want to go any further into that because there's really no reason. It's the presumption of innocence, but it's because of that case is the catalyst, and it did not involve his daughter. It's because of that case we're here for this. And it had not been for that, I know he would have successfully completed this agreement. So what's the need to protect the public? Well, now he's not around his daughter. And it's basically just him and working, but he's not an alcoholic. He's not a drug user. He's a hardworking man, pays his taxes and supports anything he can with regard to his daughter's success. And so, Your Honor, the only thing that I can think of is I know anger management, I understand what it is, I understand what the assessment is, but sometimes I think the domestic violence assessment, which is much different, and usually that entails fall through, and also entails that the therapist needs to see the criminal complaint and as much documents as they can see. And I think sometimes that assessment may be something that may be more forthcoming, or can see if there is any issues there, because it was his daughter, and they are in a domestic relationships and the definition of it. So I think that assessment, I think it's much more in depth. And I think the anger management assessment, while it's good and it can assist, I think that the domestic violence, I think it not only covers anger management, I think it covers a whole litany of things with regard to being a father, and how you act. And yes, if you get frustrated also, I think you get frustrated, you don't throw lumber, or although I've had many times growing up where maybe my father wasn't right, but I certainly had things like that happen as well, where he was.
And that wasn't right, Mr. Davis.
Well,
that was abuse.
No, I love my father, and it made me a very successful person. He never hit me, but he would say, get going, pick it up. He never hit or hit me with any lumber or anything, but he was very hard on me. And I know my father never abused me, and he's a wonderful, wonderful father. But what I'm getting at is he was hard on me, and I think that created a lot of my success. And so I thank him for that. Now, again, this situation, had it been handled differently, maybe he pulled his daughter aside. But I think where his head's at, I really want the court to know this. His head was not to be mean to her, not to hurt her, but he wants her to be successful and have some structure. And again, I don't know anything about the mom. I don't know, but all I know is I don't think there's the same structure there as it is when it's at dad's house. And so he's the mean parent or the bad parent because of that. In any event, Your Honor, I'm asking the court to consider probation.
Defense attorney Nicholas Davis passionately argues for probation, painting a picture of a frustrated but well-meaning father. He explains that the defendant's actions were not intentional, but stemmed from frustration over his daughter's lack of responsibility. Davis emphasizes that the defendant has already completed anger management and parenting programs, showing his commitment to improvement. He requests probation with an imposed and stayed jail sentence, arguing that this approach will allow the defendant to continue supporting his family while addressing his behavior. The defense's emotional appeal adds depth to the case, leaving the audience torn between sympathy for the defendant and concern for the victim.
And this is a heavy duty. My client and I discussed this, but I think it should be probation with an imposed and stayed for the whole time. And he completed domestic violence assessment and he follow through. And that way the ball's in his court. So if anything should happen for the term of probation, then he doesn't, not 3 months, not 4 months, but the whole entire deal. I'd ask the court to consider, because he is full-time employed, that he would be allowed Huber, but I think that's a heavy hit. Put it on him, put the anvil on him, and that's an imposed and stayed for the entire time. Thank you very much.
Thank you. Ms. Bauer, do we have any victim impact statements? I have nothing in the file, so I don't know if anyone's going to make a statement. No, Your Honor.
I received nothing in terms of that.
Is this the victim in the courtroom? No, this involves a different matter? Yeah. All right. Okay. Okay. Mr. Stewart, I am now going to turn this over to you. This is going to be your opportunity for you to provide me with any statement that you wish to provide me with. And let me know anything that you wish to let me know as it relates to this matter and any other matter or any other thing that you want me to know and understand. You don't have to, but it's your only opportunity.
I don't know.
You don't have to.
You don't have to, but if you want to tell the judge anything now, this is your right to do that.
No, I don't know what's going on.
All right. Mr. Davis, I fully understand where you're going with, where you were coming from with your argument. And I fully get, and when you were telling your story of how you grew up, Mr. Davis, I get it and I understand. I too had very strict parents. I too had a father that was very strict. I too had a father that was very much like Mr. Stewart, not like your father, Mr. Davis. Not like if I am going to guess 100%, Mr. Davis, your father did not throw a board at you.
No,
I don't know if your father was angry and your father threw things when he was angry, but it's not okay. It is not okay in any way, shape, or form. No way, shape, or form. That is abuse. Even if you had zero intent to hit your daughter, that is abuse. It is abuse. It causes emotional trauma within your child to see you act like an idiot, like a jerk, like even more words that I cannot even say on the record. You were an awful parent that day. And if I read from the criminal complaint of what happened that day and how it went down, the officer responded to the address and made contact with Ben Stewart in the front seat of a pickup with juvenile 1 sitting on the passenger side of the truck. Ben told me he was taking juvenile 1 to get checked out at Burnett Medical Center. I had juvenile victim 1 get out of the truck and talk to her. Juvenile victim 1 was crying. She told me that her dad, Chris, had told her to use the tape measurer when they were working in the yard. Juvenile victim 1 had gotten dirt in the tape measure, and Chris had told her that if she did that, she would not be going deer hunting. Juvenile victim 1 then was upset and told Chris that she was going deer hunting with her uncle, Ben Stewart, and he would be taking her. Chris then threw a board at her, which hit her in her arm. Juvenile victim 1 showed me her forearm, and I could see a mark on her arm where the board had hit her, and a bruise was starting to form. Okay? And then it goes on and says that he threw the board during the argument, but didn't mean to hit juvenile 1. That's what you told the deputy. He thought she would, quote, get out of the way, quote. You thought she would, quote, get out of the way, quote. When you threw a board at her, you hoped you thought she would get out of the way. When you were mad that she got dirt in the tape measure, and now you said, nope, sorry, I'm taking away your pleasure of going deer hunting, which is great to teach a young lady, by the way. And you said, nope, I'm taking away your fun. You're no longer going deer hunting because you got dirt in my tape measure, because I love my tools, because that's what I do. And so I got mad. No, you're not going deer hunting. And then she said, no, Dad. In parentheses, I may not be going deer hunting with you, Dad. I'm going deer hunting with my uncle. And I'm going to presume uncle's your brother, Ben, because Ben at that time, I'm guessing, was siding with juvenile 1. Because how it laid down here is you thought she would get out of the way. You don't get angry over things like dirt in a tape measure. It's not like she was not picking up the lumber. It's not like she wasn't doing her homework. It's not like she wasn't cleaning up her room. She got dirt in the tape measure. And you got upset when she wasn't listening because you were trying to take something of pleasure away from her. And she said, no, Dad, too bad. So you threw a board at her. And your excuse was, I thought she'd get out of the way. But she didn't. Because you know what? A man throwing a board, a heavy, I'm going to guess 2x4, goes fast. If you've ever taken science class or a calculus class or anything like that, and you do all of those mathematical formulations, they go pretty fast. Okay? kind of hard for, I think, a 15-year-old, if I'm recalling correctly, to get out of the way